Hello, good afternoon, and welcome to our continuing focus on the Supreme Court, the Supreme Petition. That is the show that we have this afternoon. We've been here for most of the week, and the big story we are following this afternoon, big developments coming out of the Supreme Court, that the ruling that was supposed to have happened in the next half hour or so has now been pushed to 7 p.m. A set of rulings on about 8 questions that were raised in court last night. That will now come at 7 p.m. and the hearing proper for the petition will begin tomorrow, 9 a.m. So that is the development that we've been following over the last hour or so. And my colleague Sophia Wanuna is still at the Supreme Court. Sophia, the other thing that we are following this afternoon is the political side of this. Some would say NASA was supposed to be there. Earlier you spoke to Simba Arati and they said they were coming to the court or at least somewhere near there. Do we have any development whether they have arrived there? Do we know if they are coming? What's going on?
Joe, nobody here. Things are quiet except for a little bit of human traffic. I suppose folk that are coming from church nearby. But the cordon is still in place, and perhaps we'll just run you through the security measures that have been put in place here in the cordons around the vicinity of the Supreme Court. On my right, which is one half of City Way, you see that truck over there with that wire mesh in terms of a cordon on one side and on the other, and another truck on standby, and there are security officers all around that particular location as well. That is to ensure there are no cars literally coming into this vicinity. And then this is Wabera Street, again another one on that end in the middle of the track, that cordon, and this has just been added. This yellow cordon right here has just been added as an extra, so this is now to bar human traffic from this particular circle, if you like, where we are standing this afternoon. And then going about to my other right side is still City Hall way down the road, and again another cordon. And we're just talking to the security agents here, the officers rather. And we're talking to us about, of course, the expectation that those NASA supporters would be coming here for that vigil. And what they had indicated is that they will not even be allowed close to the cordons as we see them. Remember, when we spoke to Simba Arati, he'd said that they intend to hold their vigil right here within this circle. But the officers saying they will not be allowed anywhere within this circle. So we'll wait to see if they plan to come. Of course, we also have my colleague Mark Namaswa, who's tracking the NASA principals. So if they do come, we will have it live. But Joe, before I hand it back to you, some information that we have now received. Remember earlier, we were talking about those issues for determination, that when the parties were unable to agree on how they want to converge or merge the issues, if you like, for determination in the hearing, then the matters went before the judges. So the information we're getting now, the judges will not rule on the issues, they will not determine them, status quo will prevail. What that means is that the 24 issues that NASA has raised for determination, they will argue those 24 issues, and the other issues raised by the various parties, those are the issues that they will argue in court. So there will not be forming of those issues, if you like, the judges putting them together for the parties as had been expected. Too many rulings we are hearing from the sources here, what has led to the postponement to tomorrow, and also to this kind of a thinking that status quo prevails. Everyone submits depending on the issues they raised, Joe.
That's a very interesting development there, because last night it appeared that they were going to look at them, and in fact they were inviting the lawyers to sort of see whether they could get some consent. Do we have any reason behind this? What are you hearing from your sources around the judiciary?
Yeah, Joe, what we're hearing is that there's too many rulings, that, you know, adding the question of the issues and the questions to be presented, or if you like, prayers before the court during the petition would just add that workload, make it heavier than it already is. And so what the formulating of those will remain as they had been highlighted, as they had been crafted by the petitioner, by the first, second and third respondents as well. So, Joe, Joe, it will be interesting to see even going forward this question of time, because with most of the issues emerging, time is an underlying factor, a huge underlying factor, because the reason, there's this kind of decision is because there isn't time really to get again into what are those issues going to be, and that you have all of these applications and requests and prayers that have been made in a very short time span the Supreme Court and the parties must work with. So that is really a pressure point, not only for the judges, but all the parties here at the Supreme Court.
Like time is a real amicus curiae in this whole thing. I mean, it looks like time is a real party in this case. So I'll let you go and get more information for us at the Supreme Court. Sophia Wanuna reporting for us live from the Supreme Court, where we are now hearing that the judges will not, in fact, be ruling on the issues that will be discussed before the courts, but in fact that every party will be arguing whatever they have laid out as the issues. And I'll be speaking to my guests a little later to just find out what that exactly means. But before that, I want to go to Mark Namaswa, who is somewhere in the CBD. Mark, if you can hear me right now, where exactly are you? Are you still at the All Saints Cathedral, or are you now somewhere else? Where is this meeting that NASA principals are supposed to attend?
Okay, currently I'm at the junction around Nyerere Road, just a few, in between All Saints Cathedral and we're heading to another location where we expect, at the Serena, we expect NASA principals to speak to us. We also told that they might be launching their vigil there, so that's the spot we're heading to, just to get to know exactly what is the plan, what's the way forward. We asked concerning their issue about MPs elect under the NASA banner, whether they are going to take the oath of office or not. Now, Raila Odinga declined to comment on that matter. So we will head to the Serena and try and press on and see whether we can be able to extract answers concerning that. But as it stands now, he has spoken about exuding confidence of him heading to Canaan, as he has popularly labeled his presidential ambition. So right now, our journey takes us straight from All Saints Cathedral to Serena and see what will be up waiting for us there. Back to you, Ageo.
But Mark, that's not exactly what they had said earlier. They had said they were going to go near the court. I mean, from my understanding of the geography of the CBD, Serena isn't that close to the Supreme Court. Is it now a change of plan that now they are not going to go to the Supreme Court, but they'll still have their vigil or whatever they called it elsewhere?
Yeah, it's quite interesting how things keep changing from time to time. We do not know whether it is by accident or design, but that's where we are heading to. The last brief he's just given us indicated that the journey leads to the Serena. But we still have eyes at the Supreme Court. We still have eyes and feet to get us to the Serena. So let us go and see what is waiting us at the Serena, as we also contact our other eyes at the Supreme Court to see exactly what are they up to. What are we going to witness in the coming hours or days?
Thank you very much, Mark Namaswa, reporting there from the CBD. And as he mentioned, Raila Odinga spoke a short while ago from the All Saints Cathedral about what their plans are for the day and what he's looking forward to with regards to the developments in the country. Let's just listen to what Raila Odinga said a few moments ago.
Characterize the government of Jubilee for the last 4.5 years. Thank you.
So you do believe that the journey to Canaan is still very much on course?
Yes, we are on course. We are on course. You know, it was never an easy journey, even by the Bible, the story of the Bible. Remember when they met those huge giants in Canaan, but the Lord overpowered them and put them in the hands of the Israelites, and they were able to reach their destination. So our journey is still very much on course.
Last time we checked, you had plans of launching a vigil outside the Supreme Court, which was declined by the police. What's the way forward as it stands now?
It was not us. I mean, we don't seek any permission. The law is very clear. If Kenyans want to do something, they just notify the police. So that police officer does not understand the law. He is notified so that he can provide security. Not that he can give permission. We are past that. We did away with the Public Order Act. We did away with the Chiefs Authority Act. Those laws no longer exist in our country. It's a free country. It's freedom of association, freedom of assembly, freedom of speech, all guaranteed in our Constitution. That police officer needs to read his law better.
There was the proposal by some of
All right, NASA leader Raila Odinga speaking there a short while ago, commenting on various issues, including that vigil that they say they will still continue with. But as we understand it now, it does appear that whatever it is, it will not be happening very close to the Supreme Court. But we'll wait and see how that unfolds in the next hour or so. But allow me now to welcome one more guest. We have been here with Dr. Musumba. Thank you very much. Jotham Arua is our guest, advocate of the High Court, managing partner at Rachiera Molo Advocates, but also a law lecturer at Jomo Kenyatta University of Agriculture and Technology. Thank you very much, Jotham. And I will just start you with this question that I think we were discussing a little bit earlier here, that there's a court case that is going out there, but people out here are also making their own impressions and so on about this. Going by what happens around the world, how important is it that what is done in the court is also perceived in a particular way by the members of the public, or is that not an issue when a case, especially of this nature, is going on?
Generally, as a matter of law, it is not expected that there should be a very heated debate going on around the very issues that the court is dealing with, because that has the effect of also influencing the judges, and it is perceived to be itself an interference with the independence of the judiciary, because the judges may also buy into some of the sentiments being expressed. And that is why we have what is called sub judice rule, that effectively blocks any debate on an issue that is going on. But it should also be understood that it is not very easy to expect the public not to comment on an issue that is as hot as the current presidential election debate is. In fact, there is a constitutional right to express an opinion on any issue. And there is also a right to engage in any debate. So it is therefore impossible, so to speak, to say that nobody should talk about the very issues that the court is dealing with. What is important is a very delicate balance must now be maintained between healthy discussion on the issues that the court is dealing with and influencing the outcome of the decision.
What is that boundary? How do you know, well, now this is crossing the line?
It is, to be honest, it's extremely difficult to know exactly when one is crossing the line. But the most important point is for the judges to appreciate that it is impossible to expect the Kenyan people to keep quiet.
So they need to rise above that noise
Precisely.
And still do what they were going to do anyway.
They should be able to act in accordance with their oath of office and ignore what the public is saying. Mm-hmm. That is the duty, in my view, a very onerous duty that right now falls on my brothers in the bench.
Joe, can I just...
what dimension you want? Yes, yes.
Can I just add something to what my colleague here has said with regard to prosecuting issues in the court of public opinion vis-a-vis prosecuting them in the Supreme Court, which is the legal arena for prosecuting. This is to give a small example, which I think most people will be familiar with. We saw the case of O.J. Simpson, the first case where he was accused of killing his wife, where at the same time as the case was going on in court, there was a huge, brouhaha outside the courtroom taking place in the court of public opinion, and we saw race relations being really stirred up. And eventually, the ruling that was given by the court, many people have said subsequently, was actually a ruling that was based on what was going on in the court of public opinion, where the issues that, the sentiments that were whipped up within the public with respect to race. You're looking at the judges who are in that, the judge in the trial. You're looking at the jury. You're trying to examine the race of the jurors, and you're thinking that if the jurors were this race, it would have been the outcome would have been this way or that way. So that played a lot into. That is what people think, the ultimate ruling that was given. So just to be able to expound on just what my colleague had just said.
Yeah, because I would imagine that even by just sitting there and watching those judges and you have no knowledge of how the law actually works, there's a sense in which, because this is a political question, people make their own opinions and whatever. And I would imagine that at the end of it all, whatever ruling this, the bench comes up with, there'll be people who are saying, but why did they not take that into account? Isn't that inevitable that at the end of the day, we will, as a public out here, scrutinize whatever they do, even though we might not have a technical understanding of the law?
Yes, our Constitution entrenches the principle of accountability. And the principle of accountability binds everybody who is exercising public authority, more so the judges. So they are accountable to Kenyans, and they cannot avoid being blamed if there is a perception that there is something that they have not done right. Mm-hmm. But it's important also for the Kenyan public to appreciate that the role that the judges are playing is an extremely difficult one, because they are also part of the Kenyan polity. And they are not completely immune from the kind of political views or perceptions that the rest of the Kenyan public hold. But it is expected of them to put all such political views aside and focus only on the law and on their oath of office, and remain faithful to the letter and the spirit of the law, ignoring any political persuasion that they may have.
Okay, so let me go quickly to what my colleague Sophia was reporting on a short while ago, a decision that seems to have come from the judges that they won't be ruling on or framing the issues as it were, because from last night it appeared that each party had defined the issues as they understood them differently. I think NASA had 24, 28 or something like that, and then IEBC had 2 or 3. So at what point does that become important? Is it normal? Is it something that, how will it play out if you have, everybody seems to have defined these, or are the judges now saying, if you think that you can argue 28 things in 6 hours, you deal with it? What seems to be going on here? Because they're citing time as an issue.
Well, we need to start from the theoretical principle, which is that courts of law deal and deal only with issues brought before them. It is not expected that a court would go outside the issues framed and deal with any other matter. Now, in this case, the main ground that is being advanced by NASA is that the declaration ought not to have been made, that the president, the Honorable Uhuru Kenyatta, did not win and was therefore declared as president illegally. One would then argue that that is the only issue. Mm-hmm. But unfortunately, that cannot be so, because there are reasons why they make such contentions. And these reasons or grounds may themselves be framed as issues. And this is how we end up with a total of 28 grounds for NASA, while the Jubilee side would prefer to remain narrow with the question whether the declaration was proper. Now, the law envisages that in a contest of this nature, there may be differences of opinion with regards to what ought to be the issues. And so the law gives the parties the first opportunity to agree among themselves on the issues, to the extent that they can do that. Mm-hmm. But if it becomes impossible for the parties to agree on the issues, then it is for the court to now frame the issues. And this is captured by the Supreme Court Presidential Elections Regulations of 2017, which clearly state that if the parties fail to agree on the issues, then the court should frame the issues. In fact, the rules proceed to state that during the first pretrial conference, the issues should be determined, meaning that as at yesterday night, the Supreme Court should have given us the issues if the parties failed to agree on them. But that did not happen. And of course, we understand that they were operating in very tight situation at the moment. And so what it would appear they have decided to do is to let the parties argue whatever issues they deem proper.
They believe to be the issue.
Yes.
Yeah.
And that is also perfectly lawful. In fact, with that decision, it can properly be said that it is the decision of the court that has expanded.
That is the ruling?
Yes.
Okay.
Already we can say that they have made a ruling on that to allow the 28 issues for NASA and the 3 or 2 issues for Jubilee.
Okay. Linda, what do you make of that?
Oh, I wanted to say that I think that leaving the court not actually engaging itself with trying to frame the issues, or in this, I would say, is to reframe them, because the issues have already been framed by the parties, and to therefore narrow them down or collapse them in any way would be reframing. I think the court has probably decided to allow, parties to proceed as they had initially thought, because if the court reframes the issues, there's the possibility of, the element of bias being raised. So that if you collapse 28 issues into 4 issues, in the way you know best how to, as the Supreme Court, then, for example, NASA feels that there was an issue that was very critical, which they wanted to be specifically flagged out, and you've collapsed into 4 that now don't seem intelligible or coherent, then of course that again, the element of bias would be raised. So I think in my view, this is the safest way to dispense with the issue of being accused of bias, even though the court properly has the jurisdiction to actually do the issue of reframing those issues.
Now, Jotham, there's the whole issue of time. Yes. That keeps coming up every time something happens. Time is the issue. How far can this go, and what do you foresee, because we're almost closing this, as the debate that ought to happen after this? Because one gets the feeling that if there was time, we would do this. If we had time, we would do this.
Yes, time is a serious problem. And I should say that it makes it extremely difficult, if not impossible, to do a proper presidential election. Now, it should be appreciated, Joe, that what is going on is supposed to be a hearing. Mm-hmm. And under Section 80 of the Election Act, the court is supposed to determine certain issues. And in a presidential election, given the fact that we are dealing with over 40,000 polling stations, expecting the petitioner to be able to avail all this evidence is almost impossible. Yet, that is what would be required if you are to successfully convince the whole Kenyan people that the election was not proper. So, if the time we have is such that you cannot do even the basic step that you need to take to satisfy the question, or to answer the question whether the declaration was valid or invalid. So time is a big problem, and what makes it worse is the fact that it is entrenched in the Constitution. Last time, Kenyans were denied the opportunity of knowing who won the election simply because of time. It was not possible for the respondents to respond to the affidavit that was filed. And that was the reason why it was knocked off. And by knocking out that affidavit, it means all the evidence went. We are again facing the same challenge today because we need to know as a people whether the number of people who are alleged to have voted are the actual people who voted. It is very easy to do that by just checking the results as against the information contained in the BVR machines. It is possible to tell whether the Form 34As that were used to generate Form 34Bs were genuine.
But you require it to be a function of time.
You would need to compare them against what was sent electronically and against...
But some people, and we've talked about this, I think, a couple of times, some people say that that debate came up in 2013, and somehow we never resolved it. Now we find ourselves with another presidential petition. We are talking about time. Probably after this, we'll discuss it a little bit. What fails to happen after this kind of thing so that the learnings can actually help in future cases of a similar nature?
We expect the politicians to take the initiative of amending the Constitution to enlarge the time. In my view, it would be better to extend time to even 30 days because we can do more within 30 days rather than doing what, in my view, will not be useful to most of us. Because if the court cannot do the scrutiny, the court cannot examine the primary documents that were used to make the declaration, then we will simply be saying in almost every election, you have failed to prove, you have failed to prove. And it's important also to note that judging by the 2013 decision, the onus is placed on the petitioner, yet the petitioner has no access to the information. Now that is a problem. Because if we are to maintain the onus with the petitioner, then we should transfer the responsibility of verification.
By law to the other side?
Yes.
Okay, so we are finishing this.
Joe,
your final thoughts on this? What the most important thing is that we should be thinking about now as we head towards the day there will be a decision made?
Okay, firstly, just to say quickly that the element of time brings out the necessity for teamwork. Teamwork among legal teams. For example, it would be very difficult for NASA to succeed to be able to prosecute its case well if they had only one lawyer. It means you must bring more than one lawyer on board. But the number of lawyers you bring on board, whether it is too many or that is left to them. So that means that there has to be teamwork within the legal teams of each of the parties. There has to be teamwork also on the bench. The Supreme Court also, being a number of 7, must also work together in concert in order to be able to deliver a very difficult decision within a very tight deadline. My thoughts going forward, I think, is to really wait and see the rulings. The rulings that will be given today at 7 p.m. are going to guide a lot, to a large extent, the nature of business going forward. It's going to define the parameters. And of course, as we said previously, this is now where we shall see showmanship. The legal counsel of the different parties putting their best foot forward to bring alive what is in their pleadings. Because remember, they've already put on paper what they want to say. But now it's an opportunity for them to orally be able to present what they're saying in a way that can persuade, in a way that can sway the bench to see things from their point of view. So it's really a question of putting your best foot forward.
All right, Justin, before we finish, anything, 30 seconds, where we go from here?
Yes, my view is, as I was saying, we could also deal with this problem by simply transferring the onus of proof to IEBC. And we must appreciate that IEBC also has a constitutional mandate to deliver a credible election. And therefore, it should be their duty to convince Kenyans that the declaration was proper and lawful, rather than just leaving it at the doorsteps of the the petitioners.
All right, thank you very much. And these are, of course, discussions that we'll continue to have. Remember that the ruling that was supposed to have happened around now, actually, 2 p.m., is now been moved to 7 p.m. So tonight at 7, there will be a set of rulings on all the applications that were made last night. And tomorrow morning at 9 a.m., that is when the hearing for the main petition begins. This has been the Supreme Petition. We've been looking at different aspects of this, and we'll keep you updated throughout the afternoon on this news channel, KTN News. And do have a lovely, lovely afternoon. Thank you very much for watching.
Court. An amicus curiae brief is a legal opinion or testimony presented by someone interested in influencing the outcome of a case, but who is not party to the case.